13th Lecture Note. The title of this lecture note is Criminal Law. We are going to look at this in four aspects. The first, the introduction to criminal law. The second, crime. The third, elements of criminal offences. The fourth, criminal penalties. Let us look at the first aspect, introduction to criminal law. Criminal law is a set of legal norms established by the highest state authorities that determine the criminality and punishability of acts, the grounds for criminal liability, the system of punishments, the procedure and conditions for their appointment, the types, procedures, and conditions for applying the other measures of criminal legal influence, as well as the procedures for exemption from criminal liability and punishment. Criminal law is the only fully codified branch of Russian law. Its only normative source is the Criminal Code, that is, Criminal Code of the Russian Federation. But of great importance in this area also have the resolution of the Plenum of the Supreme Court of the Russian Federation, containing explanations on the interpretation and application of certain provisions of the Criminal Code, subject to obligatory consideration by the courts. Many norms of the Criminal Code of the Russian Federation have blank dispositions, that is, they refer to sources of other branches of law, for example, violations of labor protection rules or traffic regulation that cause serious consequences. Tasks of criminal law. 1. Protection of human and civil rights and freedoms, property, public order and public security, the environment, the constitutional order from criminal encroachment. 2. Prevention, that is prevention from Latin preventio, of crimes under penalty of punishment. Principle of criminal law, that is basic provision used in the fight against crime, mandatory for legislation, law enforcement agency, and citizens. Legality, that is the principle that only acts described in the Criminal Code of the Russian Federation are considered crimes. Equality, the principles that are equal before the criminal law regardless of gender, race, nationality, language, origin, and other circumstances. Justice is a principle that states that the punishment applied to a person who has committed a crime must correspond to the nature and degree of public danger of the crime, the circumstance of its commission, and the identity of the perpetrator. That is, many factors are taken into account: how exactly the crime is committed, whether the criminal repents, whether the harm is made, amends, what are the conditions of his life, socialization, and so on. Let us look at the second aspect, crime. A crime is a culpable committed, socially dangerous act prohibited by the Criminal Code of the Russian Federation under threat of punishment. Crimes, depending on the degree of public danger and form of guilt, are of four categories, that is minor, moderate, serious, and especially serious. The composition of a crime is a set of objective and subjective features that characterize, according to the criminal law, a certain socially dangerous act as a crime. 1. Object implies social relations protected by the Criminal Code of the Russian Federation, which are encroached upon by subject, that is property right, right of life, and so on. 2. Subject, a delinquent person who has committed a crime. In criminal law, sanity is important, that is, if it is absent, restricted, it is not a punishment but compulsory medical measure. And the age of this person, as a general rule, from 16 years for individual crimes, theft, robbery, murder, and so on, from 14 years. Third, the objective side of the crime is characterized by features that characterize the criminal act itself, its form, that is action or omission, socially dangerous consequences, the causal relationship between them, the circumstance of the time and place, the situation, the method, means, and tools of the crime. 4. The subjective side implies the psychological attitude of the criminal to the crime. It includes, first of all, guilt in the form of 1. Intent, direct or indirect, intentional desire to commit a crime, awareness of the public danger of their actions and their consequence, or their conscious assumption. 2. Carelessness in the form of frivolity or negligence, or that is lack of awareness that the actions will lead to danger despite the fact that the person could and should have been aware of them. In addition, the subjective side includes the goal, the motives for committing the crime, and the emotional state, for example, the effect. To exclude the criminality of an act, to exclude the criminality of an act can such set as necessary defense, extreme necessity, infliction of harm, and detention of the criminal. Crimes can be completed or incomplete, that is, preparation, creation of condition, is punishable for serious and especially serious compositions, attempts, that is, implementation of criminal intent failed for reasons beyond the control of the person. The third aspect, elements of criminal offense. The criminal code is divided into general, that is, regulating the features of the criminal law, concept and categories of the specifics of the responsibility of individual subject, and special, that is, special elements of crimes and penalties for them. The special part of the criminal code consists of sections that include chapters. In the first place, it puts crimes against individual, her life and health, for example, murder, Article 105, freedom, honor and dignity, sexual integrity, freedom, for example, rape, Article 131, constitutional rights and freedoms, for example, violation of the principle of equity, Article 136, example of non-working dead articles, against the family and minors. They are crimes in the sphere of economy, against property, for example, theft, Article 158, in the sphere of economic activity, for example, non-payment of taxes on a large scale, Article 199, against public security and public order, for example, illegal possession of weapons, Article 222, illegal sales of drugs, Article 228, sub 1, against state power, military service, peace and security, mankind. Let us now look at the fourth aspect, criminal penalty. Punishment in criminal law is a measure of state influence applied to a person found guilty of committing a crime, consisting in the deprivation of restriction of his rights and freedoms. Punishment is applied in order to restore social justice as well as to correct the convicted person and prevent the commission of new crimes. Punishments are basic, that is, compulsory labor, correctional labor, restriction on military service, forced labor, arrest, detention in a disciplinary military unit, imprisonment for a certain period of or life, the death penalty. Since 1996, not applicable in the Russian Federation. A moratorium is imposed, and additional fine, deprivation of the right to hold certain position or engage in certain activities, and restriction of freedom are applied as both basic and additional punishment. Deprivation of a special military or honorary title, class rank and state awards only as additional punishment. The Criminal Code establishes the circumstances mitigating criminal responsibility. The list is not exhaustive. For example, confession, reparation, the presence of severe disease, and aggravating her, that is, their list is closed. For example, the recurrence of the offense, part of a group of persons with use of office position. The grounds for exemption from criminal responsibility, reconciliation with the victim, active repentance, and so on. And punishment, parole, suspension. And with that, we come to the end of the 13th lecture. Thanks.